Let us discuss marriages in community of property. If you marry without an antenuptial contract, you will by default be married in community of property. In this system of marriage, the spouses' estates will both share their assets and liabilities. Should one spouse default on debt, the debtor can act against both spouses. There is only one estate. Each spouse has the right of disposal over the assets, provided they obtain consent from the other spouse, as they are equal concurrent managers of the joint estate. Now, let us have a look at a few things that will affect you or be affected whilst you are married in community of property. Assets. All of the assets belong to each spouse before getting married, and all of the assets accumulated during the marriage will fall into the joint estate. There are a few exceptions where certain assets may not be included in a joint estate, and these includes inheritances and legacies accrued during the marriage, donations received from third parties and the spouse, unless otherwise agreed, bequests made in a will subject to a marital exclusion clause, certain life insurance policies. Also, certain damages are excluded from the joint estate. This includes any amount recovered by way of damages other than damages for patrimonial loss because of a delict committed against them. Does not fall into the joint estate but becomes their own separate property. Damages in respect of bodily injuries suffered by a spouse and attributable either wholly or in part to the fault of the other spouse, and these damages do not fall into the joint estate but become the separate property of the injured spouse. Liabilities of the joint estate. All the liabilities that are incurred by each spouse prior to the marriage and during the marriage will be considered as liabilities of the joint estate. Each spouse has the capability of binding the joint estate through their actions. Looking at insolvency when married in community of property. If the existing marriage is in community of property, in principle there is one joint estate. Both spouses will receive the status of an insolvent and the joint estate will be sequestrated. Each spouse has equal management of the joint estate. However, the consent of the other spouse is needed for certain transactions. Although you must acquire the consent of the other spouse to alienate joint assets of the estate, written consent is only required in certain instances. There are instances where no consent from the other spouse is needed. That is, where one spouse may act independently to perform acts that are binding on the joint estate. The main advantages of a marriage in community of property is you don't have to enter into a particular contract before getting married. If you are the financial weaker spouse, you get to share in the assets of your more affluent spouse. In the end, the only advantage to couples marrying in community of property is that it encourages a relationship of equality for both legal and financial matters. The disadvantages of marriage in community of property is if you are an economically stronger spouse, you are obliged to share your assets with your spouse. You are jointly liable for each other's debts. The joint administration of the estate is somewhat complicated. When a marriage starts to fail, it can become difficult to obtain joint consent. If a spouse is financially reckless, then the result will be that the other spouse becomes liable for those debts incurred. If each spouse runs their own individual business, then being married in community of property will render their business vulnerable to creditors who will make claims against both spouses. Very little can be done in such instances to protect the other spouse from this vulnerability.